Welcome back, and thank you for staying with All Angles. Now, the High Court in Pretoria has ordered the Ekurhuleni Municipality to pay over R1 million for failing to provide housing and land. This after the Metro failed to comply with the 2017 court order, which compelled it to provide houses and land to the 133 applicants living in the Winnie Mandela informal settlement by December 2018. The applicants are being represented by the Socio-Economic Rights Institute of South Africa and Section 27. Section 27 attorney Zeenat Sujee joins us now live to give us more. Zeenat, thank you very much for your time here on ENCA. I mean, for me, what's quite compelling in this particular case is that it started all the way in 2015, 2016. They were ordered to build houses for more than 130 people by a certain date. I think it was December of 2017. They couldn't, and the government kept going back to court to ask for an extension. But they would ask for an extension, according to what you're saying, literally a day before the expiry of that particular extension. Sounds to me like a government that really doesn't care. And in these extensions that they were asking for, do you know at all if they had ever even started a project, at least there was foundation to build these houses at all, or did they just sit and do nothing?
Well, good afternoon, Ms. Eklund. Thank you so much for having me. So I think it's important for us to understand a bit on the facts. These residents that comprise of 134 residents approximately were actually applied for their housing subsidies in terms of the upgrading of informal settlements program, in terms of the housing code in 2009. They were put on, they were supposed to receive these subsidies. These houses were then allocated to other people, which has left these applicants in very squalid circumstances, without adequate water and sanitation, and just dilapidated circumstances. So this gave rise to them having to assert their right in terms of promises and obviously in terms of the grant of the subsidies already being granted over 20 years ago already. And it was at this juncture where they did approach the court. So that's where the case stems from. And obviously, so there was a plan, because the municipality were aware of the subsidies, of the applications being made, of the subsidies being granted, and they had to be, and people were already given, or other people were allocated these houses. So, you know, the applicants in this particular case had to approach the courts to have their right to title and to be given the houses that they were promised.
Yeah, Zeenat, you know, to me, this describes, at least to me as a South African, a government that doesn't care about the poor, despises the poor, in fact, to a point where it's paying very expensive lawyers, I assume, all the way from 2015 until this year, to have the courts side with them not to actually give these 130 beneficiaries what they were promised by the same government.
I totally agree, Ms. Echo. I think that, you know, the complexity of this litigation is so indicative of just what you've explained, of the nonchalance of government. So you see that this case commenced in 2015. We were back in where the court ordered for houses to be built at the end of 2018. It was then appealed to the Supreme Court of Appeal. From the Supreme Court of Appeal, which extended the deadline to June of 2019, a few days before the deadline of the end of June 2019, the municipality goes back to court on a variation. This is where the applicants have now then counter-applied, right? They made a counter-application for constitutional damages. The High Court dismissed the application for variation, as well as the applicant's claim for constitutional damages. It then gets appealed to the Constitutional Court. The Constitutional Court at the end of 2021 dismissed the application, or rather it was a split decision, but the majority found against the applicants. So we actually see that the time period of this is so indicative of just dilatory conduct, and also such a waste of resources going through the courts instead of just providing housing.
And when you look at it, I mean, from 2015, the administration then was under Mondli Gungubelo, who was still the mayor of the city of Ekurhuleni, all the way to the person who's the mayor now, to your Tanya Campbell, etc. So it's different people who've been letting these people down and not following the courts, or rather using the courts to their advantage because they have the money to do so. So how do we know, Zeenat, that this time they'll actually follow what the court said? Because since 2015, they've been evading.
Yes, so I think this is really pivotal, because I think this court application was so important, and for two reasons. Is that even though the applicants had to approach court now for a second time on contempt, we see that the court has made really strong orders, right? The first being that in order for contempt of court, that the mayor has to pay $1,330,000 rand to the registrar of the court. And this is so because they were held to be in contempt. And I should explain that when one is held in a contempt, you can either ask for penalty or fine, or you could ask for a committal, right, which is imprisonment of a public official in this case. So they have to pay for this. And I think what also gives us some kind of relief as Section 27, as we entered as amicus in this case, was on a very important legal point, was to say that, and this is something where the Constitutional Court in this case said that all applicants claiming socioeconomic rights should not be entitled to constitutional damages. And what the High Court does, and what Batlania J had ordered, was the important, where she then says that the applicant should not be precluded from coming back to claim this constitutional damages for the delays and the continued breach of their right to adequate housing. And I think that's the important point to see. And this is why constitutional damages is such an important remedy for those claiming their socioeconomic rights, is to ensure that other people who have a claim to vindicate their rights to socioeconomic rights would, it could claim constitutional damages, and it might also be a deterrent for municipalities and public officials. Yes, for any future breach.
Yeah.
So that is.
Thank you so much, Zeenat. And then they wonder, right, why the poor end up living in dilapidated buildings in the city of Johannesburg, because the government itself is not fulfilling some of the promises that it makes, and instead will blame organizations such as yours and Siri, and even an act of 1998 that they themselves actually put into law. Zeenat, thank you very much for your time. Zeenat Sujee is an attorney at Section 27.